Go ahead.
Okay, I'm Jean Thompson from the League of Women Voters. I can't tell you how excited I am about all the people arriving, and I know that they're coming from all different places, and we wanted to get one little question in before we start. How many of you are lawyers? Oh, wow. How many are criminal law? Yeah, they'll learn a lot today, you're right. I'm going to have Scott Wood, he's the head of the Restorative Justice Department, who is our host today, and I want to thank them very much for letting us use their facilities.
Good morning. Good morning. On behalf of Loyola Law School, I want to welcome you and tell you how delighted we are to be able to provide this space. I want to congratulate the League and all the co-sponsors for putting on this extraordinary program with this remarkable panel. I want to tell you a quick story. Last year, I went to Folsom Prison, and I met an inmate named Steve Bell. He's a handsome guy, about 48 years old, and during our short time together, he told me this story. He said, I grew up in a troubled home. It was a bad news place. I had no dad. From the time I was a very little guy, I was filled with anger. And then to make matters worse, it turns out I became an alcoholic, and I got into drugs. And when I was 19 years old, I broke into an unoccupied house with some friends. We were caught. It was strike one. I served 18 months in jail for that. Time went by, another 5-6 years, and with my addictions, making it very difficult for me to do the right thing and think well. What happened was I was walking down the street one day and I looked into somebody's open garage door and I saw this beautiful leather coat hanging there waiting to be snatched. So I snatched it. Strike two. He served 2 years for stealing the leather jacket. 11 years then went by, and during that time, Steve got his life together. He got a trade. He was an electrician. He was married. He was living a productive life, but his addictions came back to visit him. So 11 years later, now it's 1999, he stole a bike. Strike three. Steve Bell is in the 13th year of a 45-year sentence for stealing the bike. So I would look forward to this moment so that I could bring Steve to you and tell you about that encounter with him, because I think it serves to put a human face, I hope, on our discussions today, and think of the hundreds, if not thousands, of Steve Bells that are sitting there in their cells today, hoping that we make some progress here. Thank you very much.
Thank you very much. I wanted to thank all the people that have helped put this together. We have had a lot of help from our sponsors and supporters, and I'm sure that most of the people here came from one of the sponsors or supporters, because I know they're not all League members, although we'd love to have you. So I'm going to introduce Judge Wesley. And it could take me 3 days to go through his bio. So I'm going to skip a little. You have all the little bios on the back of the agenda. After graduating from Southwestern University School of Law, Judge Wesley joined the Los Angeles Public Defender's Office. Then he began private practice, and then he went on to be a Superior Court Commissioner, presiding over a juvenile court, a felony trial court. Then he became a Superior Court Commissioner. Then he got appointed to the Superior Court. And he is now the Assistant Presiding Judge of the Superior Court. He has been very active in the sentencing kinds of programs. He has served on the LA County Bar Association committees. He has also started a teen court, which is a very interesting court, and I think there are several around in the country or in the state. And he has a new program called Shades, Stopping Hate and Delinquency by Empowering Students. These are all very unique and very interesting programs that he's been involved in. He's got so many awards, I can't even begin. Special recognition for combating hate, Anti-Defamation League, Certificate of Proclamation for Teen Court, Certificate of Recognition for service to the LA's Office of Gang Reduction and Youth Development, which I just mentioned because the League had a program on that once. We have to get our little bit in too. And he has had an award from the Judicial Council, Jurist of the Year. And I want to very enthusiastically welcome Judge Wesley.
Well, thank you very much for having us here today. We really appreciate it. Good morning to all of you. We have a very distinguished panel today, if you exclude the moderator. And so let me introduce them to you. And as I call your name, I think the people in the back can't read your signs. So the first one I'll introduce is Professor Laurie Levinson from Loyola Law School. Deputy Chief Probation Officer Reaver Bingham, Los Angeles County Probation Department. Laurel Gord from Friends Committee on Legislation. Kylie Schilling, Executive Director of Violence Prevention Coalition. Hannah Dershowitz, ACLU, Southern California. And the gentleman over here, if you don't recognize this is Sheriff Baca. Now, I wanted to bring this up because the sheriff just said something that's really true. The last time I was on a panel with the sheriff was 1995. I was a Superior Court Commissioner. He was a commander in the Sheriff's Department. And we were speaking at Optimist Boys Home. We have been friends ever since. And the sheriff just said, well, you see, history repeats itself. And what I'm going to do is I'm going to spend about 15 minutes showing you how history repeats itself. So where to begin? All of these panelists, by the way, could probably talk. This is a very broad subject. All of the panelists, I'm sure, could talk for 3 hours on sentencing and legislation involving sentencing, but we're not going to do it that way. What we've decided to do is for me to give you an overview of sentencing for the last 160 years in 15 minutes, and then we'll turn it over to the panel, and we'll go through a discussion, and we'll all chime in whenever we feel we want to. So where to begin? Well, I read an article, and it said, and I thought it summarized everything pretty well. After 160 years, California's criminal punishment system is in a precarious position. Its prisons are overcrowded, its recidivism rate is extremely high, its correction budget is enormous, its sentencing system is incoherent. I thought that was a pretty good summary. There are experts and public officials who agree that reducing our reliance on incarceration would be a sensible approach to prison overcrowding, but most are reluctant to say so publicly. So, is the solution to build more beds or change the sentencing law and create a funded philosophy of rehabilitation? The question has been at the heart of a tug-of-war between the legislature and the executive branches throughout California's history. Who is it that is responsible for alleviating jail overcrowding? And I think some of that is what we're going to talk about today. So some history here is sure to be helpful. California became a state in 1850. You're all going to leave here learning some history. The original sentencing system contained no provision regarding philosophies of punishment or the purpose of sentencing. The code simply defined crime as an act or omission forbidden by law with the following punishments: death, imprisonment, fine, removal from office, or disqualification to hold or enjoy any office, honor, trust, or profit in the state of California. Felonies were punishable by imprisonment by death or imprisonment in the state prison. All other offenses were misdemeanors. This was found in a document called the Act to Regulate Proceedings in Criminal Cases in 1850. There was another act in 1850, an act concerning crimes and punishments. It set forth the substantive provisions of the criminal law and the penalties one would pay for violating them. So each crime had a sentencing range, and the law gave the judge the discretion to sentence within that range, with no guidance as how to pick what sentence it should be within that range. When you were sentenced, it was until the judgment is complied with. No such thing as good time, work time. There were no provisions for conditional release, probation. There was no condition for post-release supervision, parole. That was to come later. Now, for those of you that don't practice law, so what that meant was if I had a range from 3 to 15, I could pick any one of those sentences. It was up to me, the judge. So I could say 7 years, and the person would do 7 years. Doesn't work that way now, but that's how it worked in 1850 when we started. Now remember, I said history is instructive. Well, I just said that felonies were punishable by imprisonment in the state prison in 1850. The problem was we didn't have a state prison in 1850. So the act simply provided that the county jail of each county was to be deemed a state prison. Interesting, huh, Sheriff? In 1851, California created a prison system. And in 1852, construction began on the first prison in California, San Quentin. And I had a question for one of the panelists when I was talking to them on the phone. It was modeled after Eastern prisons. Okay, so San Quentin was being built, but in the meantime, now that we were starting construction on a prison, they decided they had to have a place to put the felons. So all felons in the state of California were sent to San Francisco. And they were housed on a ship called the Wabun, docked in San Francisco Bay. And when the Wabun got full, they went to San Francisco City Jail. When I read about this, there were two things that I found very interesting. And one was that San Quentin, once it was built, was really overcrowded from the start. It was completed in the early 1850s. By 1858, they had 600 prisoners and only 62 cells. But secondly, the early prison administrators wanted the prison to be a place where criminals could reform themselves and not just be detained. This is 1850. But the more crowded it became, the harder it became to provide rehabilitative services. So they had to build more beds, and pretty soon they had to build a new prison, and guess what? They built Folsom. Now, how do I know this? How do I know that the prison directors were interested in reform? I found an article that had a quote by a prison director that wrote a letter in 1859. And he said, "In the present crowded condition of the prison of San Quentin, no system can be devised for the instruction of these unfortunate men, morally or intellectually. They cannot be separated or classified so as to aid those who desire to improve themselves. There should be a classification by age, by character, and every effort should be made to reclaim the young and the novices. It is certainly no credit to the state to throw these men back upon society worse in all respects than when they entered prison. Another director said it is a great mistake to suppose that all of these men are hardened to crime and beyond the reach of reform." So I know how the prison directors were thinking back in 1859. 1891, California decided it was going to have its first parole law. So they enacted the first parole law, which allowed first-time offenders convicted of any crime other than murder to apply for parole. And the Board of Prison Directors, the newly formed Board of Prison Directors, was going to decide that. In 1901, they threw murder in also, so everything was eligible for parole. The Board of Prison Directors had the authority to release people, but they were reluctant to do so because they were afraid of public criticism. So very few people got released. Once they were released, there was no active parole supervision. They simply reported to the board once a month. California's early parole was not focused on rehabilitation. It was a way to relieve jail overcrowding. What? Did I hear somebody say, what's new? Rather than confront the issue head-on and look at sentences and rehabilitation, the executive branch and the legislature used parole as a mechanism for reducing prison overcrowding by releasing offenders whose determinate sentences had been legislatively fixed. Probation joined in 1903. And I talked to Reaver, and Reaver had it. I asked Reaver, when did probation start? He told me, 1903. And so people could be placed on probation rather than sentenced to state prison, where there were circumstances in mitigation of the punishment or where the ends of justice would be served. The focus in 1903 was juvenile, but it did apply to adults. Again, the public really wasn't ready for this. And how do we know that? LA Times, January 10th, 1914. Judges often grant probation without the exercise of the slightest judgment, often in response to weeping and sentimental women. California newspapers, after 1917 on, began to really question and push for an abolishment of the present sentencing plan because they didn't like the fixed term, arguing that it would be better to have what we call an indeterminate term because that would bring more consistency and it would give more time to reform the majority of offenders and keep violent offenders incarcerated longer. At the same time, judges were urged to impose more probationary sentences to ameliorate jail overcrowding. Just like parole in 1893, indeterminate sentencing would give legislators and the governor a way to avoid the risk of telling their constituents that they were lowering prison sentences. In fact, since the ranges for the sentences remained intact, the public had no reason to believe that the sentencing length would be affected by the new law. So in May 1917, the legislature enacted the new California Penal Code section 1168. Anybody practicing criminal law knows that section. The Indeterminate Sentencing Act, keeping intact the minimum and maximum ranges. Now, what does that mean for those of you that don't practice law? So remember I told you before I had a determined sentence between a range. So if it was 3 to 15, I could give 7 years. So now the judge wouldn't give 7 years. The judge would say, I'm sentencing you to 3 to 15. And when they feel you're rehabilitated, they can let you out. So they can let them out after a year, they can let them out after 15 years. And the thought was that this would help. One prisoner challenged the new law, complaining that the delegation of authority to the Board of Prison Directors to decide when he was going to get out was a violation of his constitutional rights. And that went to the Supreme Court. It's a case from 1918. It's called In re Lee. And I put it in here because I like what the court said. Because I say this all the time. I say this to the sheriff. I say this to anybody that wants to listen to me. The judicial branch of government is entrusted with the function of determining the guilt of the individual and imposing the sentence provided by law for the offense for which the individual has been found guilty. The actual carrying out of the sentence and the application of various provisions ameliorating the same are administrative in character and properly exercised by an administrative body. The sheriff will talk to you in a while. He'll talk about an early release program. The judges of our court take the position we sentence according to the law. 60 years, we had indeterminate sentencing. When I became a public defender in 1972, we had indeterminate sentencing. A lot of our cases that we had sentences 3 to life, 5 to life, 3 to 20, whatever. And the judge would sentence indeterminately and let the Board of Prison Terms decide. But in the 60s and 70s, the parole board decisions came under great scrutiny. Some people perceived the board's release decisions to show class and race bias. At the same time, other people were concerned the board was much too lenient and not interested in rehabilitation so much as reducing prison populations. Sound familiar? So there was pressure from the public to make sentencing and parole decisions more consistent and increase the uniformity of sentencing. There was also pressure from the courts to comply with the statutory mandate to make individualized sentencing decisions based on a prisoner's ability to demonstrate they had successfully rehabilitated. The legislature resolved the issue in 1976 when Governor Jerry Brown signed the Determinate Sentencing Act. The Determinate Sentencing Act. I was a young public defender. It rocked our world. Because now we had the new system, the triads. But it was a mix. We had, every particular case had 3 possible sentences. The low-level offenses all carried state, if they were felonies, had 16 months, 2 or 3 years in state prison. The presumptive term was the middle term. If you wanted to go down, you had to state the reasons. If you wanted to go up, you had to state the reasons. That was the Determinate Sentencing Act, and it was all spelled out. Just like AB 109, this was not a brief law. It went on for hundreds and hundreds of pages. Just like AB 9, it was under Governor Brown. Just like AB 109, it was designed to handle jail overcrowding. This law declared the purpose of incarceration, though, was punishment. Did not talk about rehabilitation. Established this system of determinate sentences, which we call now the triads. And it also set forth some enhancements. Now, over the years, from 77 up to the present time, I was counting. I stopped at 80 enhancements that had been added to this. And so, not only the crime, but it's the enhancements that add on time. And we can talk about that if you want later on. The law left intact some indeterminate sentences. Murders still carried, a second-degree murder carried 15 to life, a first-degree murder carried 25 to life. Those remained. In some other cases, some other crimes carried life sentences. What was the motivating force behind this? I think that they shortened the sentences, hoping that they would relieve jail overcrowding. At that time, proponents argued that California had the longest sentences in the United States. And they also said that studies showed that sentenced prisoners who had done over 5 years in prison showed no significant rehabilitation after that period. So whatever the purpose was, jail overcrowding became exacerbated. And then comes 3 strikes, 1994. You've all heard about it. I'll give you a quick explanation. It was a law aimed at habitual offenders. In a nutshell, the law provides that one defendant who has a serious or violent felony conviction must receive twice the term that they would otherwise receive for the conviction. It also provides that the defendant has 2 or more such prior convictions shall be sentenced to an indeterminate, remember I told you indeterminate. It has, so it's open-ended. Indeterminate imprisonment for life with a minimum of 25 years or 3 times the underlying conviction offense, or a conviction plus the applicable enhancements, whichever is greater. So it became, we'd sit down and we'd add up all the different things and see which offense. It usually was 25 to life in most cases. It also provided reduced credits for 3 strikers, so they only got 20% custody credit. Most people get more than that, and the sheriff could talk to you about that. And it required that defendants go to prison. They could not get probation. They could not get county jail. Last time I looked, there was an article I cut out and brought from May 27, 2011. 8,700 prisoners were serving life under the 3 strikes law right now in California. $10 billion is the cost in California. $10 billion is the cost in California to keep the current 3-strike population for the next 25 years. So that's a portion of the jail overcrowding. And now we get to AB 109. AB 109 was introduced January 10th, 2011 as a spot bill without substantive statutory amendments. For those of you that follow legislation, what that means, it's a holding bill. It's holding its place. The only statement of the legislature's intent to enact statutory changes to the Budget Act of 2011. The bill was not amended to include criminal justice realignment provisions until March 14th, 2011. Those changes were available for review on the Legislative Council's website from March 15th to March 17th. I know this because I started reviewing it. It was over 500 pages long. Nobody, and I mean nobody, had time to digest one of the biggest changes to the criminal justice system in California's history. And in fact, in 48 hours, it went from idea to law. Signed by the governor on April 4, 2011, to become effective July 1st, 2011. To become effective July 1st, 2011, and all of the justice partners, not just the courts, but the sheriffs around the state, the probation officers around the state said, whoa, whoa, come on, give us some breathing space. We got to figure out how to do this. You're making it the law, but we have to be able to work this out. So they said, oh, okay, we'll give you till October. Am I right? This is what they did. They gave us till October. When it was made clear that we couldn't do it, but they gave us till October. And we started making those changes. And then AB 117 made clarifying and technical amendments to the Criminal Justice Realignment Act on September 2nd because there were things that just simply had to be fixed. There were mandates that could not be done. So we corrected some of those. I'll talk about what it does in a nutshell, but let me back up a little bit because I've been giving you history as to maybe why AB 109 happened. So I'll pick it up from 1976 when Governor Brown signed the Determinant Sentencing Act, completely changing the way the justice system was operated. And what I did was I looked at a couple of newspaper articles to sort of tell me what was going on at the time. And I read one, the Metropolitan News, which is a local legal newspaper, May 25, 2011. History should record the late 70s as an era of pivotal socioeconomic change in California. A new wave of international migration, a shift from industrial to post-industrial economy, and a new baby boom. The eruption of crime became a powerful political issue. By happenstance, Jerry Brown was governor, and the crime issue was especially vexing for him. He was a longtime opponent of capital punishment. He responded by signing dozens and dozens of lock-em-up anti-crime bills, and among them determinate sentencing. Not surprisingly, the new laws and the tougher attitudes by prosecutors and judges began to raise the prison population. When Brown became governor, the state had 20,000 men and women behind bars, and no new prisons had been built in years. By the end of his governorship, prisons were packed, and corrections officials were begging for new space. Brown signed a $495 million bond issue to jumpstart prison construction. Now, during the 80s and 90s, billions of dollars were spent on new prisons. During that time, the Department of Corrections mushroomed to thousands of employees. The California Correctional Peace Officers Association became a very powerful political force, and inmate population grew to over 150,000. Overcrowding generated lawsuits, and a federal judge appointed a receiver to run prison medical care. The Supreme Court has now ruled that California must reduce overcrowding by building more prisons, releasing inmates, or shifting them to other facilities. Now, when Governor Brown signed the Determinate Sentencing Act in 1976, as I said, the population of the prisons was 20 to 25,000 prisoners. In 2008, the population was 171,314 prisoners. The system was simply not designed to hold that many prisoners. Now, the two lawsuits that resulted in the recent Supreme Court decision were these. Coleman versus Wilson. That was brought in 1990 by, and became Coleman versus Schwarzenegger because they were going after the governor. In this case, a mentally ill inmate filed a lawsuit alleging mental health care provided in the prisons was so inadequate that it violated their rights under the Eighth Amendment. The federal court agreed and granted a permanent injunction in 1995. Then there was Plata versus Davis, and then it became Plata versus Schwarzenegger. 10 prisoners filed suit alleging that the state was being deliberately indifferent to their medical needs and a violation of the Eighth Amendment. 4 years later, the federal court appointed a receiver, finding the system was broken beyond repair. A 3-judge panel was appointed to consider whether to impose a cap on the number of inmates that could be housed in California prisons, and the panel combined the two suits and granted a request for a cap on prisoners. Since overcrowding was the primary cause of substandard care, they ordered that the state reduce the population by between 38,000 and 46,000. Now, Governor Schwarzenegger had an attorney general at that time by the name of Jerry Brown. He appealed, believing that the more conservative Supreme Court would not dare tell a state how to run its prisons. Right. Okay. So in a 5-4 decision, the Supreme Court of the United States gave us 2 years to shrink the number of prisoners by 33,000. And what was the reaction of the conservatives on it? Because this was a 5-4 decision. And I'm going to give you the reactions because I think that lends to discussion here. Scalia, Antonin Scalia, in his dissent, said the majority had affirmed what is perhaps the most radical injunction issued by a court in the nation's history. He added, "Terrible things are sure to happen as a consequence of this outrageous order." Steve Cooley's not here today, but Steve Cooley would agree with him. LA Times, May 25, 2011. In his dissent on Monday's 5-4 decision, Samuel A. Alito said, "Sending more inmates to prison has led to lower crime rates in California and elsewhere. From 1992 to 2009, the violent crime rate dropped by 58% in California and 43% nationwide. Releasing inmates early, as some officials say, may be necessary in order to meet the court's demands, will lead to an increase in crime." However, in that same article, The Times, there was a professor from Loyola named Laurie Levinson, a former federal prosecutor and veteran criminal law scholar, who pointed out that high recidivism rate and past cuts for prison rehabilitation and education. She said, you're going to have higher recidivism rates because of the past cuts, and that there's no rehabilitation going on in education. And so without that, it's a recipe for even worse jail overcrowding. We, quote, "We have to stop the insanity of sending nonviolent drug offenders and low-level theft offenders to prison for life. We have to stop the revolving door of parolees being returned for minor offenses." Now, interestingly, Steve Cooley would agree with that, because he believes that 3 strikes should not apply to nonviolent offenders. So let me go back to AB 109 for 1 second, then I'm going to stop, because I want you to understand what AB 109 does. So in a nutshell, here's what AB 109 does. It makes significant changes to the sentencing laws. It changes the definition of felony. 1850, felony, any crime for which you go to state prison. Okay? AB 109, felony, any crime for which you go to county jail for more than a year or state prison. It changes the supervision of people convicted of felonies, where and how they will serve their sentences. It shifts substantial parole responsibilities to the counties and local courts. Quoting from the legislation, criminal justice policies that rely on building and operating new prisons to address community safety concerns are simply not sustainable. That's shorthand for saying, okay, county, we're shifting the burden to you. The new supervision and revocation schemes for low-level offenders have new names that become part of the jargon of criminal speak, I call it. So, post-release community supervision for non-non-nons. Non-non-nons are non-violent, non-serious, non-sex offenders. And that's very significant, because a whole class of cases, non-non-nons, can no longer be sent to state prison. So even though they commit a felony, the non-non-nons go to county jail. The sheriff has to deal with them. And we have also something called mandatory supervision under 1170H5 of the Penal Code, and that's what we call a split sentence. So I can sentence a person, a non-non-non, to county jail for 3 years. I could give him 2 of the 3 years and put him on probation for the last year. And I know Hannah would like that. And we can talk about that. They're doing that in some places. So this is all effective July And now, in July 2013, the criminal courts in each county are going to be responsible for conducting all revocation proceedings in 4 distinct categories of supervision. This is new. We used to have parole and probation. We now have probation, mandatory supervision, post-release community supervision, and parole. They were all treated with different procedures. And so we got together, I'm part of this group that's been working on this, and we decided to seek legislation that would treat these all under 1203.2 of the Penal Code, which is the way we've been treating probation violations since the 1900s. And if we do that, we know that they're getting all of their constitutional rights, and it's also the same procedure for all types of post-conviction proceedings. Had no resistance from district attorneys, from the legislature, from any place else. It is working its way through. And Laurel, you may know where that is. I don't really know. Okay. Okay, so we're in the process of trying to apply one procedure throughout the state, but you can see this is a work in progress. This is still going on. So, that's a quick summary of the history of sentencing in California in 15 minutes or so. But I think it leads to some discussion. And I'm going to start with Laurel Gord. And the reason I'm going to start with Laurel Gord is because legislation is still going on.
Yes.
And the question is still there. More beds, more jail cells, tougher sentences, or funded philosophy of rehabilitation. And I'll give it to Laurel.
Okay. Well, you heard the history of attempts by the legislature to deal with California's addiction to locking people up. And sadly, things have not changed much. And people call it, some people are calling it drive-by legislation, where there's a terrible crime that hits the news and a legislator decides they'll get points in their home district by bringing forward a bill, a sentencing enhancement, or a new form of sentencing, and there's very little resistance to passing those bills. This has led, as somebody pointed out to me, that at this point 80% of murder cases are now considered capital cases, which means they can be tried for the death penalty. You know, what is a special circumstance has just increased, which means there are many more people serving life without parole. The best thing in regards to this that the legislature has been able to do is that the Senate, the state Senate, under Mark Leno and now under Lonnie Hancock, have been, who have been chairs of the Public Safety Committee in the Senate, have tried to really hold the line about letting any bills get out that would increase sentencing, because they're so aware of the problems with the overcrowding. I wanted to say the Friends Committee on Legislation of California has been working in this, was formed in 1952 in response to the loyalty oath, but we've been focusing on the prison expansion issue since the 70s. So our observation is that term limits seem to have made the problem worse, because there are no longer legislators with safe seats who are kind of willing to go out on a limb and do something that's politically dangerous. And you also have people chairing important committees who have very little political experience. And they're always running for higher office, because they know they're going to get out and you know, be termed out. So an experience. So there's been very, you know, there's been changes in the criminal justice system, you know, and this realignment is huge, but there's been very little movement in terms of changing the length of sentences. In 2009, there was as part of a package of bills to try to curb prison spending, there was an attempt to form a sentencing commission. And the idea was that because it's so politically dangerous for legislators to appear in any way soft on crime, and so they don't do it, that a commission of professionals in the field, a range of professionals, would make recommendations on what sentencing laws should be, and then the legislature would have some political cover to either vote yes or no on it. It was fiercely contested by the sheriffs and by law enforcement, and it went down to defeat. And since then, there's been no more attempts at a sentencing commission. One of the interesting things that happened was this tough on crime has been a bipartisan stance. You know, that the Democrats as well as Republicans are terrified of appearing soft on crime. And with the Sentencing Commission, there were, and this illustrates the issue of the term limits, as well as all the Republicans voting against it, 4 Democratic Assembly members voted against it. All of them were being termed out and were running for higher office. And one of them was my personal assembly member. So then, now we actually, there's some movement just recently, and it's SB 9, Senate Bill 9, the Fair Sentencing for Youth Act. It's and it just passed in the Assembly, but I wanted to say something about its history. After a very hard battle, it finally passed in the Senate. It was first introduced as Senate Bill 399 in 2009, and it came up for a vote in 2010. After the election, when my assembly member lost his bid, had already lost his bid for Attorney General, so we thought, okay, well maybe he'll be a little more amenable to this. And he, I wanted to say, the bill started out as an effort, the idea when Human Rights Watch conceived of it was to do away with juvenile life without parole. And I don't know if people know that because of a crime called felony murder, a person can be sentenced, a juvenile can be sentenced to life without parole if they're present when a crime is committed that involves a murder. So, you know, I believe a bare majority or many of the juveniles sentenced to life without parole were not the trigger person. And often it happens that the crime is committed with older people who are more savvy about the criminal justice system. They plea bargain and get a less severe sentence. The juvenile who thinks, well, gosh, you know, I didn't intend for anyone to be killed, and goes to trial and ends up with life without parole. So, so this has felt like a really important bill. So, okay, so I wanted to do away with life without parole, but it soon became obvious that that was politically unfeasible. So they kept amending the bill, amending it. You know, finally, it was a juvenile sentenced to life without parole after serving 15 years. If quite a few criteria were met, could petition the court to have the sentencing portion of their trial, of their case reopened. So it was far from a get out of jail free card. So I started calling my assembly member every day, you know, because he was one of the holdouts, and they just kept amending it, trying to get the votes in the assembly. It had passed the Senate. And finally, I asked the staff person I was talking to, could you just please help me to understand this bill is so moderate, why he can't find his way to support it? And she said to me, well, this time, I don't think it's politically motivated. I thought that was very telling. And maybe I'll stop there. I do want to say that, well, I'll just stop there and let somebody else talk.
Thanks, Laura. By the way, thank you. By the way, I have a Met News article here. Supreme Court cites Eighth Amendment. This is August 17th, 2012. Cites Eighth Amendment. Says sentence of 110 years to life for a juvenile is unconstitutional. Now, I find that very interesting. This is California Supreme Court. And I have a note. I just showed this to the sheriff. I have a note about it. And my note says, so what's the judge supposed to do? What's the judge supposed to do? Follow the law? Is the judge supposed to follow the law and sentence according to the law 110 years to life? Or does the judge ignore the law and then lose his job?
Ignore the law.
Okay. Easy for you to say. Easy for you to say. Yeah. That's right. That's the right answer. And here's the problem. Nobody knows what the right answer is. And so, what did the Supreme Court do? It didn't send it back to the trial court, sent it back to the Court of Appeals, because the Court of Appeals had upheld the trial judge. So the Supreme Court said, okay, we're finding this to be unlawful, and I love it. Court of Appeals, you figure out what the right sentence is. Okay, so Sheriff, you've heard the history of this. I've told the audience, I think a lot of this falls on you, unfortunately. We had jail overcrowding, and then we were working with you on that before AB 109. So now, I have a couple questions I wrote down, so I'll give you them, and then you can talk about anything you want. So we have a new jail population. I know that the Los Angeles Superior Court is sending, under the new law, about 940 people to county jail a month. Sentenced as non-non-nons. That's new cases that would have gone to state prison that are now going to county jail. They're not as long. Some sentences are up to 16, 18 years in county jail. We never had, county jail was meant to hold people for a year. We never had sentences like that. So you have also, so now that creates a new population that needs medical care. I have a question about whether that was funded for you or not. Because you do have one of the largest medical facilities, I think, in the western United States. It's amazing. I've been there. Also, I think that has put another burden on you, and that's restitution collection. And I'm not sure that that has been worked out. Because when we sentence people to state prison, we're required to order a certain amount of restitution. And I think, I don't know how that's going to be collected by you, if at all. And then my other question is there a population shift in your jail, and are you working on this? Because now you have long-time felons, people doing long sentences, and you got them mixed in with people that are doing relatively short sentences or misdemeanors. So if you sort of address those when you talk about it, I appreciate it.
Okay, well, all right, can you hear me? No. How about now? Yeah. Better. Can someone turn up the mic? That won't happen?
You want to use this one?
Perhaps that'd be easier. Okay, how about now? Thank you. Good morning. I'm delighted to be here. The League of Women Voters has always been on the forefront of social issues since the League formed itself. Now, what's the significance of 1920, ladies? You have the right to vote, right? Okay, so here's the point. This conference today is very important. I think this University, Loyola Law School particularly, and Laura Levinson herself, she's the boss. So we're all here as your guests, and I thank you for that. The judge asked me some questions. I will get to the questions, but the comments that the judge made and the comments that were made by the lady to my left are worthy of opening up my remarks, and then I'll get to the specifics of what the judge asked me. My participation with this issue of sentencing and incarceration has been going on for quite a long time. I have 47 years of experience in the Los Angeles County Sheriff's Department, and we have a lot of functions to perform in the world of public safety, but also incarceration. Right now we're in a renaissance of opportunity, the way I look at it. And the big question on the issue here that we're discussing is, what really is the purpose of a sentence? And we have traditionally forfeited ourselves to the purpose being punishment. The truth is that our purpose in sentencing is to establish an educational path for people who obviously have fallen off of it. And that education involves the socialization of the individual with the rest of society. I will say to you very simply this, that a human being that does not value his or her own life is certainly not going to value yours or mine. And I want you to think about that. The human being that does not value his or her own life will assuredly not value the lives of others. True or false? There is the opportunity point for jails. As you know, and some of you may not know, I've embarked years ago on an education-based incarceration theory, which is more a practice. And that journey is manifesting itself right now. Of the 18,000 prisoners in the county jail, 9,000 of them are in classrooms. And the purpose of those classrooms is to help them understand the vulnerability of the human mind. Now, in my opinion, it's not only people in jail that could need a little help with this. It's people in the free society who have yet to go to jail. Our own fascination with drugs in our country and the pursuit of legalizing everything that harms the mind relative to drugs and alcohol is a real issue that I think you should bring about at a later point in time. But there's no doubt that the men and women who go to jail have not done a very good job in managing their minds and the opportunity to learn things. So where is the problem? Well, it starts at the early ages. The socialization of a child can be problematic in this crowded society today. Children are going to school alienated, fearful, and certainly not able to go home and study because there's no environment for them to study anything other than go outside if you want to avoid chaos inside your home. So therefore, there's a lot of restructuring that has to go on within the mantra of rehabilitation. That people who are basically limited in their skills must acquire another way of looking at life so they can reconstruct themselves while they're in jail. And so this early release business, or even this idea of reentry with the theory that the state put forth, that, well, 6 months before they get released, give them some classes and maybe they'll do well and not commit crime. This is nonsense. The purpose of a prison should be that the minute you enter a county jail or prison, you are on an educational plan from that very first day. And what I'm doing here, even with pre-sentenced inmates, and now my big bone is high bail for people who literally, if you can afford to be bailed out like Phil Spector was able to, he was able to post his $1 million bail. Now here's a guy that puts a gun in a woman's mouth and then, for whatever his reasons are, pulls the trigger. And he gets out on bail. At the same time, someone else that may have committed a less heinous crime is in there on high bail. And so that's the issue in terms of the inequity of some of the issues relative to bail. But that's about all I'm going to say on that point. The key here is that what are the points of rehabilitation for someone who enters pre-sentenced or has been sentenced? First of all, their reading skills have to be enhanced. A lot of them can't do that. Others are writing skills, decision-making skills, relationship skills, anger management skills, sobriety skills, mathematical skills, and there are elements of spiritual skills. We're not talking necessarily exclusively with the domains of the major religions, but that does help. And we have in the county jail 500 plus ministers and clergy types that are coming in there to help these inmates. So the point that I'm leading to, and then parenting skills and employment skills. A lot of this is what was not done in the early years for these individuals. So what then is the sheriff supposed to do? Well, the sheriff certainly has the authority to change the purpose of what jails are all about. Now, I got into it with our governor. I was on the Board of Corrections and Rehabilitation for the state prison system, and I stopped attending the meetings. And he asked me, why are you not going to these meetings? I said, because I'm not impressed with the idea of approving $200,000 for a new shed behind a probation camp or some kind of a structural program that requires an approval. I don't have time for such triviality. What you really ought to be doing is finding out ways to create classrooms in jail cells, in classrooms in day rooms, in classrooms anywhere you can find them in the state prison system, because part of the charter of that correctional board was to find ways to prevent crime. Well, what better way can you prevent crime than to help those that are in jail go to school to straighten out the problems in life that got them in jail? And so, in that regard, he paid attention to me and he disbanded that commission. And he formed a new commission that's more streamlined, that's doing things that are less bureaucratic and more to the point is how do you improve the quality of life for a person who obviously has a troubled life? And that's what we're doing right now in the state prison system. So we're moving in that direction, and the wardens and the union and all the people that I talk to in the state prisons are looking at what we're doing here in Los Angeles, because we will lead this state into education-based incarceration. That's one authority that I have that no one can interfere with, because there's no reason to, number one, but number two, someone has to take a bold step to care for these people in jail with the interest in mind that they can change. Some can't, but it's such a few. But the rest of them can. And I've seen it repeatedly over and over and over again. The next conference you choose to have here, you just say to me, bring some of these prisoners here that have gone through these programs and let them tell you whether or not what I'm saying has any validity.
Sheriff, could you tell them the problem that you have when you want to have a gang member go to class
Well,
and the gang doesn't want them to?
Well, here's what's interesting. There's somewhat of a caste system with gangs. The older veterans that have been in out-of-state prisons are trying to influence the behavior of the young ones. So in the education-based incarceration dorms that we have, the young ones wanted to go to class. The old ones said you can't go to class. We are the ones that are controlling what you do and what you don't do. And so the young ones, being young, you have to kind of admire this, said to the older ones, meaning that the older ones that threatened them physically, they basically threatened the older ones physically and said, if we don't go to these education-based incarceration classes, you're the ones that we're going to target. So the older ones are a little wiser, so they backed off. And now the young ones are going to class. So the point of it all is that people that go to jail are generally depressed about a lot of things. They don't have a high level of self-esteem because they already know they've screwed up. They already know that they're on a bad path when it comes to life skills. So because of that, the anxiety and the stress in jails is very high, and prisons. But when they're in class, they cross over from their fears of one another, and they cross beyond their fear of their doubt about whether they can learn things or not, and they become partners in the educational pursuit. And we have dozens of inmates that are mentors to other inmates and who also help teach the classes with the deputies and the staff. You see, it's a cultural shift. When you have deputies that are also doing the teaching, then they learn that the inmates are not as big a challenge to manage as they thought they were. When you just give them nothing, they become more problematic because the anxiety level goes up and little things get blown out of proportion, and then they ultimately act out and the deputies use force because they have to and that sort of thing. But the goal here is for us to understand what the human mind's capabilities are. And because our deputies are authority figures, and of course, you know, I'm an authority figure too, but you got to use this authority from the standpoint of doing something that makes sense. Now, when I went to USC in graduate school, and I qualified for my doctoral degree, I took learning theory as one of my specialties. And I'll tell you something, a lot of teachers in schools ought to take learning theory so they understand how people learn as opposed to what they should learn. If you don't know how people learn, you're not going to be as equipped to teach any subject to them. So what I believe about my background, I'm so convinced that if you want to fight crime, invest in kids properly, educationally, but also invest in prisoners because emotionally they're just like kids. If you had them down here now, if I had them with you here today, you will hear the transformation of communication go from this tough person, ratchet all the way down to this vulnerable intellectual child who is not sure whether or not they're really going to make it to read and write and spell, to analyze things appropriately, to control their emotions, to think that someone will trust them, to have some basis for their own self-worth. And this is all I'm trying to establish, is that if they have a higher self-worth, they will have a higher value for you or I. Thank you very much.
Thank you, Sheriff. Still didn't answer my question. Are you going to have a problem with the new populations, mixing the new populations? I'm really worried about that. I want to know what you think.
Well, listen, let me tell you about this AB 109 business. When AB 109 started, I supported understanding its purpose. And in all due respect, some of my other state sheriffs perhaps are more problematic about what than I am. But here's how it works. And let me tell you, this is a challenge and it's also an opportunity. And that's how I see problems. But October 1st of last year, we had the first wave of non-serious, non-violent, non-sexual offenders sentenced to the county jail from our own county court system. What happened, what was interesting, is that we had about 930 sentenced. Of the 930, about 50 of them had been in the county jail longer than a year waiting for their sentence. And by the time they got sentenced, they had already served all the time that they should have served. And so what that told me is that the high bail thing is basically a sentencing mechanism before trial. Do you get what my point here? Yeah. And so I communicated to the judges, and Judge Wesley is one of my favorite judges, obviously. And I said, you got to work on this idea that bail becomes a de facto sentence for the poor. And since they're non-nons, which means they're not serious offenders, then perhaps we can put them on an ankle bracelet system as another alternative to actually keeping them in jail. So then as we rolled along with the next month or two, the average became about 800 prisoners sentenced per month. Now today, in the county jail, we have a capacity for 20,000 prisoners. About 5,400 are non-sentences. Okay, what's going to happen here, and it's starting to happen now, is that average will go down to about 400 or 500 per month. And then, because the average sentence is 1 year, the people that were sentenced October 1st are going to get out this year on October 1st. So that'll be about the 800 so that are on that first month of sentence now getting out at the 12th month of the sentence. And so we will cycle, in all likelihood, our non population, and we will not go substantially above our cap of 20,000. Now, we're the only county, we're the largest county in the United States, and by the way, as was indicated by the judge, the first prison system in California had 20,000 inmates. LA County has 20,000 inmates. We are larger in size than 42 states' prison systems. But because of our extraordinary methods of bringing 1,000 to 2,000 people to court every day, releasing 500, accepting 500 new sentences that are of all classifications, non, and county sentences, we're able to deal with complexity at its highest order. And at the same time, because of what things you've read in the paper, we've reduced our use of force substantially in the areas that we've had to engage in use of force, because I have a force prevention policy, and I also have this education-based incarceration, which helps the inmates keep their nerve level down and they're happy being in class as opposed to in the cell. So back to your point, Judge, we are going to balance ourselves as a county, but I do need pre-sentenced ankle bracelet authority. I have some of it already, and I'm using it. But if I could get the pre-sentenced high bail situation under control, then we're going to have a better job in managing the non-nons. Right now, they're about 26 or 7% of the whole population on the sentence level. But they are a larger number in the pre-sentence level. We just have to equalize what those numbers are. Thank you.
I've been asked to remind you all to write questions if you have them. We're going to take a break at 11 o'clock, but so we've got 10 minutes left. I want to comment on something the sheriff said, and that is he's seeking the ability, if a judge sets a bail prior to trial, AB 109 gives the sheriff the authority to release them in spite of the bail being met on electronic monitoring. But he cannot do that without the permission of the Board of Supervisors. And I've been at meetings with the sheriff where the board has said, well, what do you think, court? And I've said, as far as the court is concerned, board, you can do what you want to do. Remember, I read you that case, People versus Lee. And that case says judges sentence and we set bail according to the law. After we turn them over to the executive branch, the sheriff's department, they're the administrators of it. And we are not telling them how to administer it. And I want to tell you all, so that you know, because many of you have no way of knowing this. Los Angeles County is really unique. It's unique because we have a wonderful working relationship with the Sheriff's Department. I mean, really a good working relationship. We try to solve problems together. We have a wonderful working relationship with the District Attorney's Office and the Public Defender's offices. We meet, the Sheriff has a group that gets together once a month called the Justice Group, where he has all the leaders in the different justice agencies. And the justice in Los Angeles County is a partnership. And we've been in other counties, and I have actually sat as a judge in other counties where they were at war with each other, and it didn't work very well for them. The system broke down. Jails got overcrowded. Cases weren't being moved through the system. The defendants suffered. The lawyers suffered. Everybody suffered. We have really tried to avoid that in Los Angeles County. We work very well together. We try to solve problems. We don't always agree on everything, but we do try to solve problems together. I want to do one thing. I'll take advantage of this. The sheriff said something, and I know the sheriff has always been interested in education. Sheriff said something about juveniles. I would be remiss if I didn't talk about the programs that we have, because I'm very proud of these programs. We have 3 programs in Los Angeles County. We have a teen court program that is 20 years old. It is not new. We started this in 1996, realizing that California, with 12% of the nation's youth, had 25% of the nation's incarcerated youth. And so what we tried to do was reduce the number of youth that were being incarcerated by getting at-risk youth at an early age and doing something with them. In teen court, we take real cases out of the juvenile justice system and we try them to a high school jury of students. And we start with 9th graders, 9th, 10th, 11th, and 12th graders at high school. These are real cases. You take it out of the system and try them. All these cases are first offenders. They're eligible for what we call informal diversion, but this is part of the diversion program. We are partnered with the probation department and the schools in Los Angeles County. We also have some schools that are outside of Los Angeles County. We have 17 of these teen courts and 2 to open this year. So we'll have 19 teen courts in Los Angeles County, reaching about 10,000 students a year. In addition, the SHADES program that was briefly mentioned by Gene, is Stop Hate and Delinquency by Empowering Students, is a separate program where we're partnered with the Museum of Tolerance. And that was created because although juvenile crime has been on the decrease in the last few years, and I'd like to think that all of the early intervention programs that exist are helping, bullying and hate crimes are on the rise. And it's really easy also with cyberbullying. It's pervasive now. It's not like one kid's picking on you. It's like it's sent out to the whole school. So we started this program 5 years ago. I partnered with the Museum of Tolerance to train my same teen court students. They go through a 5-day training program at the Museum of Tolerance to learn how to try hate crimes and bias crimes. We've done a couple of them. They've been in the newspapers. If you want to see one, you can go to CBS Bullying, because CBS filmed one of them a few months ago. But we've now started that, and also we're getting referrals on that from the schools, from the district attorney's office, and from probation. So that program is really expanding. In addition, there's another organization called the California Association of Youth Courts. When we started teen court in Los Angeles County in 1992 with Judge Jaime Corral, there were 78 youth courts in the United States, 3 in California, all started in 1992. Today, there's a National Association of Youth Courts and a California Association of Youth Courts. I'm president of the California Association of Youth Courts. We have about 1,300 youth courts now in the United States, handling about 100,000 cases a year. So this program is growing. It's an intervention program, and it's trying to catch these kids before they get to my court. One of the last cases I tried, I sentenced a young man to death. He was 22 years old. He killed 2 people. So I don't want to have to do that. I want to reach these kids before they get to that stage. So we have about 2 minutes. I don't really want to start anybody, because we're going to take a break and come back. So let's do this. Let me just ask the other panelists, based on what you've heard so far, does anybody have a comment? Pamela, do you have anything?
I did. I wrote down a couple of comments. Well, I guess I would just thank Sheriff Baca for talking about some of the important issues that he's talked about with the philosophy that he's bringing to it, because I think that changing inequities in the bail system and fixing some of the pretrial issues are exactly the kind of leadership that Los Angeles County needs to show in implementing robustly and thoughtfully the purposes of AB 109.
So when we come back, and I'm going to ask you to talk about would it be a good idea to send people out of state if we run out of room, or even out of the county, if we run out of room in our jail?
I'd be happy to talk about that.
I'm going to give you an opportunity to talk about that. I thought you might. And also, if you have ideas as to sentencing changes that you think make sense with respect to, especially with respect to drug offenders. I actually went through some statistics after I talked to you that I found very interesting.
Great.
And then we'll come to each one of the other speakers. Perhaps they've heard something in the first 3. But I think it's about 3 minutes till then. Let's take a break.